like you. Be strong to hold the powers of the sun. To dream.
Let's listen to Pavarotti.
Only one.
Hello, welcome to The Revealing. I'm your host, Pavarotti, here to discuss the Idaho 4 case. In this episode, we're going to go over some of the court docs that hit recently that I haven't discussed, and there is a couple of things in there that have me fired up, let me tell you. One of the things is, it looks like after looking at it very closely, the judge does have the ability to rule based on the law against the 16B sanctions. It would be a morally incorrect decision by him, but legally, I mean, he would have basis to do it. But that's one thing. The other thing is, hidden in all of these docs was one of the pieces of discovery that the defense has not received. And let me tell you, it is probably the most important piece of discovery in the entire case. And this should be the simplest thing for the prosecution to have provided in discovery. And I think it tells the entire story of the Idaho 4 case against Brian Kohberger in this atrocity, in this whole sham of a trial. And it really upsets me. And we're going to get into it in this one. Now, some of the other court docs have let us garner a little bit more information about other things. I'm going to update you on that. But then we're going to talk about these things I'm mentioning now because I'm fired up on this. Hang with me, folks. Okay, the first one we're going to look at is this stipulated motion to seal state's amended expert disclosure, R.E. Lawrence Mowry, S10. And that's not a pickup truck, folks. That's S10. That's a attachment, an exhibit. So you can see here that they are filing an order sealing the amended expert disclosure, R.E. Lawrence Mowry, S10, and all attached exhibits herein because release or disclosure would interfere with enforcement proceedings. It would disclose the identity of a confidential source. I mean, it would do all kinds of stuff, apparently. I don't know what they're amending about his disclosure, though. That's interesting that they filed the disclosure and then they filed an amendment to it that fast. But we know that Lawrence Mowry is going to be testifying on Exhibit S10. So let's take a look at Exhibit S10, and then let's add Lawrence Mowry to our expert list. Okay, so we gathered from another one of the docs that Exhibit S10, S13, and S14, which Mowry we know now is the expert for S10, the state disclosed forensic detectives. These disclosures, now Mowry is an expert forensic detective now. These disclosures specifically listed each forensic item to which the witnesses would testify regarding. The witness's expertise is the process of extracting and identifying the data that is on each of the listed devices. The contents of each of these devices have been disclosed to defendant. Any opinion related to that extraction, whether connection was found or not, is an expert opinion. As a result, the disclosures meet the requirements of Rule 16b-7. I love whether a connection was found or not. That means they didn't find any connections in most of the stuff that they were actually trying to find connections in. Now, we know Mowry was involved in, Apple warrants and Google warrants. He was also involved in creating the cast data from the AT&T warrant. So we now know what he's going to be testifying to. It's device extraction data from devices. So let's add him to our witness list and place him where he's supposed to be. Okay, so we're really starting to fill this list out now. You can see now we've got under device data, we've got one of the experts testifying against Mr. Kohberger is going to be Lawrence Mowry. And the other thing that somebody pointed out to me in my comments on my last video that I showed the expert list is I had 10 DNA experts listed for 15 through 25, and he pointed out that that's actually 11 experts. So thank you for doing that, because I did overlook that, and you are absolutely correct. So 15 through 25, we know are DNA experts. We don't know what 13 and 14 are going to be testifying to that the defense doesn't have a problem with. But we do know now that we've got 2 other device data experts that we don't know who they are, a blood spatter expert, and then there's 3 more that we have not identified, or 5 really that we haven't identified altogether. But we will, because we've already got a lot of that list filled out. Okay, now this is the big one. The reply to state's objection to defendant's motion to compel. Yeah, I lost my train of thought there. Motion to compel material and for sanctions. So this is the defendant's, the defense, their reply to the state's objection to the defendant's motion to compel for I-16BR material and for sanctions. All right, we went over the state's objection in my last doc video, so now this is the defendant's reply to that state's objection, and it is telling in a couple of different ways. I'm not going to read this whole thing to you because it is, I believe, 5 pages. So I have gone through and pulled out pertinent parts. Okay, you'll see the Idaho Supreme Court has pronounced rules governing criminal discovery through Idaho criminal rules. That's the ICR that you see always listed in this. Mr. Kohberger asserts that the state's failure to disclose expert opinions and supporting data violates his rights under both constitutions. Failure to properly disclose expert opinions by merely disclosing a list or topics an expert may testify about or leaving open-ended opinions is, in essence, shifts the burden to Mr. Kohberger. This failure to disclose expert opinions not only prevents Mr. Kohberger from confronting evidence against him, but also prevents him from assessing his need to file motions in limine and motions to exclude expert witnesses who do not meet Idaho's evidentiary standard. And then they cite the rules of evidence 702, 703, 704, and 705. And then they say otherwise known as a Daubert-Frye hearing. Now, this one kind of confuses me, and this one led me to the conclusion that the judge can't overrule this objection, and he can do it on a law fact base. All right, number one, they cite, and I'm going to be critical on the defense here, just like I'm critical on the prosecution, but they cite otherwise known as a Daubert-Frye hearing. Daubert-Frye does not apply to Idaho, but Rule 702 does, and is not good. Okay, so let's take a look at Daubert-Frye and how it doesn't apply. So I don't know why they would put that in there. And we'll look at what does apply, which is Rule 702 of the Idaho criminal rules. So you can see it says, no, Idaho does not use the Daubert or Frye standards for expert witness testimony. So why the heck would they cite that in their reply? Instead, Idaho uses Rule 702 of its rules of evidence. This rule states that an expert can testify if the court determines that they're qualified by knowledge, skill, experience, training, or education. The party offering the expert must establish their qualifications. So, as far as qualifications, a witness who is qualified as an expert by knowledge, skill, experience, training, and or education may testify in the form of an opinion or otherwise if the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact in issue. Now, it does go on to state in Rules 704, 705, and 706 that the expert does not have to have knowledge of what they're giving their opinion on, as long as they have general knowledge of the subject involved. which leads me to believe that they don't have to have an expert opinion actually written out on what they're going to base their opinion on. Their opinion is their opinion. So I think the defense may lose this battle. And the reason I think they may lose that battle is not on moral grounds. We all know it's morally correct to provide the opinion, all the facts and data around the opinion so that the defense can prepare for it. But legally, there's an out. And I think anytime there's going to be a legal out in this thing for Judge Hippler, he's probably going to take it. And the other part is the argument, which I thought was a good, strong, fact-based argument based on the law, is actually a little bit more of a nuanced argument. So in nuanced arguments, I don't see Judge Hippler ruling in favor of the defense on these things. So as far as him throwing it out and providing sanctions at this point, I don't think that's going to happen. I do think that there are going to be some significant sanctions coming later, though, and that's what the defense has been prepping for a long time. And I do believe a lot of the evidence is going to be suppressed as well. But let's go a little bit further into this thing, because I'm going to show you some stuff that really makes me mad, and we know that it's a travesty. Okay, so let's keep going. The court has stated sealed exhibits S1 through S25. The court has the state's sealed exhibits S1 through S25. The state's filing consists of over 400 pages, mostly curriculum vitae, which is their background and qualifications of the named witnesses, and very few details of expert opinions, with a few exceptions. Approximately, now this is where I think the defense is really going to have their best chance of getting sanctions and getting things suppressed and getting judgments in their favor, is because of the discovery. And the reason I say that is there is precedent in Idaho recently with the Lori Vallow case. When it comes to discovery, that's when the judges will rule in the defense's favor. And this is a good example of that. Approximately 2,000 pages of discovery are referenced in the DNA disclosures. The court does not have the discovery pages in the expert disclosures, but for one example attached to state's objection as S1, most of the disclosures have catch-all phrases that an expert will rely, this right here kills me, rely on the work of unnamed others. Now that is where the travesty is going to come in, because these experts are going to be testifying on the work of unnamed others. And when you get into the DNA on this case, including the IgG, the STR, everything, the handling of the actual matter, the physical matter, the DNA, you got chain of custody issues. You've got all kinds of things. So how are they going to have experts relying on the work of unnamed others? They need to name the others and get them in there on the stand too and grill them. That the disclosure is meant to be an aid, but does not encompass all the findings, impressions, conclusions, or materials related to this expert's involvement in the case. Or that the disclosure does not in any way is what that should be, limit the scope of the expert's testimony. So what they're really focusing in here on is the DNA, the most important aspect of the case, and the fact that there's no disclosures and these experts are going to be testifying on the work of unnamed others. And I'm going to show you why I'm focusing in on that so hard here in just a second, because it's a bunch of bullshit. It's terrible. Mr. Koberger cannot prepare for the unknown opinion of an expert that would be proffered for the first time on the witness stand in front of a jury. And this is why I was throwing a fit in a video the other day when it comes to deposing the witnesses. You see, she should be able to depose these witnesses to know what they're going to testify to on the stand. But since you can't do that, then a proper disclosure should be made so that she doesn't have to proffer them on the stand for the first time. She's going to have to ask questions she does not know the answer to. And that is not how a trial is supposed to go, folks. This right here is a good argument Hippler should adhere to for moral purposes, but he won't because of legal purposes for him to be able to not judge in their favor, I'm afraid. And you can see some of the expert disclosures are extremely broad and encompass topics that are not touched upon in any reports or discovery provided. So these experts are going to testify on stuff that there's no reports for or discovery provided. So that means they're going to testify on stuff that they have not provided discovery for, which means they can blindside the defense in the trial. BS. And let me show you what one thing that they're going to be trying to blindside them with, and it's the most important thing of the case, and if defense doesn't have discovery on it, and it is driving me insane. Oh, it's down here. Hang on just a second. The state's objection to defendant's motion to compel acknowledges its duties under the rules. The quantity, this is where they keep hitting the quantity of the 68 terabytes. That's going to come into play later on. The disarray to which the state has both received and produced the discovery. And Mr. Koberger's argument is that given an overwhelming amount of discovery in this capital murder case, compliance with the discovery rules related to expert opinions is vital. So that is a very good closing argument that should hold some merit. Let's see if this judge is a man that has values. I mean, or is he just a judge ready to rule based on what the dadgum laws written down to state? Be informed of expert opinions being offered against him. Now, this is not unreasonable. Just because there is some standard in the law where he could deny this, it's totally not unreasonable, especially considering the implications of the outcome of this case. All they're asking for is, what the heck are you going to be testifying against me in trial with? That's all they're asking for. They're not asking to eliminate these witnesses or their opinions. All they're asking for is their opinions so that they can be prepared in trial. So this is totally something that the judge should rule in their favor for, but I bet he doesn't. Well, but we're going to see if he has any integrity. And then they pointed in down here, I showed you in a video the other day, I thought was excellent. A single terabyte is the equivalent of 75 million pages of text. Well, 75 million times 68, give me a break. The whole state of Idaho couldn't go through the discovery in this case. The discovery rules are designed to safeguard the truth-seeking functions of trial. Designed to safeguard the truth-seeking functions of trial, promote fairness, and or facilitate fair and expedited pretrial fact-gathering, and to prevent surprise at trial. That is exactly what the prosecution is trying to do, is surprise at trial. This whole rules of discovery are meant to not have that happen. So there needs to be a ruling in the defense's favor. I bet he doesn't do it. But look at this. We love these little footnotes down here. Holy bull stuff. Look at this. The state submitted Exhibit S1 to its objection as an example of discovery that qualifies as an expert report. This exhibit is a list of items collected. If the witness associated with this list is simply a chain of custody witness, an opinion is not necessary. If the witness will testify that evidence was collected in accordance with her training, proper procedure, and lab protocols, that calls for and qualifies as her opinion. If this witness testifies that others gathered evidence in accordance with proper procedure, protocols, that also qualifies as an opinion. But look at this. The lab protocols and evidence collection procedures have not been disclosed. Have not been disclosed. The lab protocols and evidence collection procedures. Now, I've said many times, when you get into a trial, the attorneys will attack law enforcement in all of their various arms, like the lab, over procedure. did you follow the procedure that's put in place? And if you don't follow the procedure, well, then that crap ain't going in there because you didn't follow the procedure, so your findings are probably not correct. They're going to request witnesses that can testify that everybody followed their proper procedure and lab protocols. But they're not going to disclose the lab procedure and protocols. And let me tell you, the lab procedure and protocols should be written in stone of what they were in November and December of 2022. So that should be just a lab protocol. Okay, they do this time. It should be set in stone, and it should be easy for the prosecution to have disclosed in the first disclosure. We are 2 years into this thing, going into the motions for suppression hearing. And this is also the motions. This is the discovery hearing. This is the final discovery hearing in the case, y'all, for the discovery motions and to be sanctions to be granted. This isn't just a motion to suppress hearing. This is the discovery hearing as well. And they're going into this hearing and they don't even have the discovery for the procedures for protocols in order to make sure that everybody in the lab and everybody that had chain of custody of this DNA followed the protocols. They don't even have the protocols. They haven't been given to them in discovery. How many discovery requests in all of those 20 motions to compel and everything else included the procedures for the DNA? See, that's why you know this is a bunch of BS. This is a travesty of justice. And this is the kind of crap right here that the defense can't get in discovery. And this is the kind of crap they should have had day one. BS. Now, I meant to put this video out yesterday, but I was working on it and I was working on that other video that I'll be putting out Wednesday night. And that one I've got to do. I'm going to make sure that everything that I say in that video, I've got the receipt to back it up. People love receipts. I don't just base my opinions on baseless, nonsense. If I say something, there is something that I've discovered either in the court docs or in the public view that back up my findings. And I do have another video I'm going to put out here in just a little bit, probably not too much longer after this one comes out. And it's going to be on that 2011-2013 Hyundai Elantra identification by Special Agent Amel. And after looking through everything I can look through, I think I understand exactly what the prosecution is going to try to do at trial. And it's not something we hadn't already expected, but it's going to be good use of one Special Agent Amel. And I'll show you how they're going to do that. But in the meantime, please like and subscribe to the channel. Post your comments, thoughts, criticisms. And until next time, Pavarotti's out.
I was an ordinary boy until I broke the rules my life destroyed.